You sued your doctor for medical malpractice, claiming that his carelessness caused you significant harm and injury. And now, during the course of your lawsuit, you learn you have to appear for what's known as a deposition, a pretrial question and answer session. Now, you're going to be questioned by the doctor's lawyer, and you are worried that when that happens, will the doctor be in the room with you, staring you down? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And in all likelihood, the answer is no. The doctor will not be in the room with you when you are being asked questions by the doctor's attorney. So let me tell you what goes on. So now you've brought a lawsuit against your doctor, right? The doctor has answered those allegations. And in all likelihood, the doctor has said, hey, why are you suing me? I did nothing wrong. And if I did something wrong, whatever I did didn't cause you harm. And then he says, you know what? If I did something wrong, and it caused you harm, your injuries really are not as bad as you claim them to be. And oh, by the way, if I did something wrong, so did you, Mr. Patient. So now he thrusts the blame on you. All right, so now during the course of the lawsuit, you will be required to appear in your lawyer's office to answer questions by the doctor's attorney. This is a process that we call a deposition. Lawyers also call it an examination before trial. And really, what is that? It's an opportunity for the doctor's lawyer to learn from you in your own words what happened, what problems you have now, what things you can and cannot do. So now it's also an opportunity for the attorney to lock you into your testimony. Now, this will take place in your lawyer's conference room. And there's no judge present, and there's no jury present. So you might be wondering, okay, what's the big deal? It's just like having a conversation. No, it's not like having a conversation. It's a formal thing, even though it's taking place in your lawyer's conference room and there's no judge or jury present and it doesn't take place in the courtroom. So what's the big deal? The big deal is that everything you say in response to a question that's asked is your testimony. It carries the same exact weight as if you are testifying at the time of trial, because everything you say is going to be recorded by someone called a court stenographer or a court reporter. So every question that is asked and every answer that you give is now recorded. And that information gets compiled and transcribed and put into a booklet called the transcript. And that forms the basis of your pretrial testimony. So now, a year or so down the road, when your case comes up for trial, if by some chance you say something at trial in response to a question that is markedly different than what you said a year earlier, now anything you said during your pretrial testimony can be used to show you contradicted yourself, and you are going to be made out to be a liar or someone who is less than truthful, because now you have one answer at trial and one answer during your pretrial testimony. So now let's get back to the title of the video. When you are questioned by the doctor's attorney during this pretrial process known as a deposition, is the doctor going to be there staring you down to make sure that you tell the truth? The answer most likely is no. He's likely not going to be there. Why not? Because the doctor is busy seeing patients, the doctor is busy doing other things in his office or operating or whatever else he does, and there's no real reason for him to be sitting in the room with you and his attorney and your lawyer and the court stenographer, because after your deposition is finished, his lawyer is going to get a copy of that transcript. And guess what? Who do you think he's going to send a copy to? To the doctor whom you sued. And at some point, the doctor will actually read through your testimony. Question, answer, question, answer. And he'll have the ability to read through it at his own convenience. He doesn't have to sit there to make sure you're telling the truth. Because the reality is, you should be telling the truth no matter what. And now, if there are significant differences in testimony between what you remember happening and what the doctor remembers happening, fine, now you've got contradictions between the two of you. But at the time you are questioned, in almost all instances, the doctor is not going to be present watching you and listening to you testify. So why do I share this great information with you? Because this is what really happens in these medical malpractice cases here in New York. You know, I do recognize you're watching this video because you probably have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started your lawsuit and you have not started a case yet, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.